The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is State versus Alexander. I'll note that Justice Berger is recused in this case. We'll hear from the appellant.
Thank you, Your Honor. May it please the court, I'm Ann Gomez from the North Carolina Office of the Appellate Defender here on behalf of Mr. Alexander, and I would like to reserve 5 minutes for rebuttal. I'll first discuss why considerations of legislative intent show that defendants who pleaded guilty should be able to make DNA testing motions. I'll then discuss why such testing would be material in this case. And it's beyond dispute that innocent defendants plead guilty. One purpose of our DNA testing statutory scheme is to exonerate the innocent. To effectuate this legislative intent, defendants who pleaded guilty should be able to make DNA testing motions. And 15A 269, the statute at issue here, does not explicitly preclude guilty plea defendants from making DNA testing motions. And the legislature knows how to say what defendants who have pleaded guilty cannot do. For example, in Chapter 15, the legislature has limited what kinds of issues a guilty plea defendant may raise on appeal. Therefore, the use of the terms verdict and defense in 15A 269 do not make this issue crystal clear, in which case it is appropriate to examine the title of the original act and what the act seeks to remedy. The title of the act is an act to assist an innocent person charged with or wrongly convicted of a criminal offense in establishing the person's innocence. And the policy of the act is to assist law enforcement in the identification, detection, or exclusion of individuals who are subjects of the investigation or prosecution of felonies or violent crimes against the person. Because it is well established that innocent people plead guilty, then if the legislative intent is to free the innocent and find the real perpetrators, it should not matter if the defendant seeking to use the statute pleaded guilty or not. As a remedial statute, 15A 269 should be read expansively to fulfill its beneficial purpose and so that it doesn't result in injustice. And that the legislature intended to seek the truth, both in cases where the defendant went to trial and where the defendant pleaded guilty, is shown by the structure of the DNA testing statutes. The statutes were designed to give innocent defendants a straightforward route to relief, even when they have exhausted all other avenues of relief. The legislature could have amended our MAR statutes to include DNA testing motions, or could have enacted DNA testing statutes that have similar provisions to our MAR statutes, such as procedural bars and exhaustion requirements. Instead, the legislature did not impose its impediments because of the importance of getting to the truth. Is the defendant the person who actually committed the crime? Further, by not adopting the MAR requirements, the legislature made a value judgment that freeing the innocent trumps the interest in the finality of a conviction. And the concurrence and the state have said that allowing guilty plea defendants to make DNA testing motions to which they've attached an affidavit of innocence makes a mockery of the DNA testing procedure. But this court's recent decision in State v. Chandler, which I've cited in my memorandum of additional authority, counsels against this notion. In Chandler, the defendant was charged with sexual assault of his granddaughter, and he attempted to plead guilty. During the plea colloquy, he said that he was in fact guilty, and then he said, no, actually, I didn't do it. I'm just wanting to plead guilty so my granddaughter doesn't have to go to court. And the trial court refused to accept the plea because the defendant said he was not guilty of the crime. This court held that the trial court erred by refusing to accept a guilty plea because under the governing statute, the trial court must accept a plea as long as it's knowing and voluntary and there's a factual basis. And that's all that's required. Therefore, under Chandler, a guilty plea is not so much a formal confession of guilt as instead just what the defendant thinks is the best thing to do under the circumstances. This court did not say that saying that one is not guilty and then pleading guilty makes a mockery of anything. And if Mr. Alexander committed perjury when he swore he was guilty at his guilty plea hearing, then keeping him in prison for decades, although he is actually innocent, mocks justice to an exponentially greater extent than does lying at a guilty plea hearing in an effort to save one's own life. And in summary, the legislature intended that guilty plea defendants should be able to make DNA testing motions. And I would now like to turn to the issue of materiality. The allegations in Mr. Alexander's motion and the attached documentation are sufficient to show that DNA testing would be material in his case. Specifically, there's a reasonable probability that if someone else's DNA had been found on the shell casings and or a projectile, Mr. Alexander would have gone to trial and he would not have been convicted. And although there are some inconsistencies among Ms. Lashley's versions of events, some of the consistent aspects of her statements and testimony would have been undermined if someone else's DNA had been found on the shell casings and projectile.
Let's kind of cut to the chase on this point, Ms. Gomez. I mean, if you were to obtain DNA testing was performed and it produced the presence of DNA of somebody other than your client, we would have that, but we would have no indication as to when the DNA was deposited or under what circumstances.
Well, that is true, Your Honor, and I want to emphasize a couple of things. First of all, this should be a low bar. We are not asking for a new trial at this point. We're asking just for the DNA testing.
I mean, it's a reasonable probability standard, which is the same thing that you've got for Brady or for ineffective assistance. So it's not a reasonable possibility. It's a reasonable probability, I think, right?
Right. So if someone else, if that wouldn't be the end of the story, it wouldn't be the end of the investigation. Oh, look, we found someone else's DNA on the shell casings. There would have been an investigation by law enforcement and the defense to see if this person had any connection to Mr. Alexander and whether the two could have committed the crime together or whether the other person could have loaded the gun. If the individual had no connection to Mr. Alexander, then this would be highly material. And so Mr. Alexander is only asking for the chance to be able to go that far.
To put it as directly as you can, Ms. Gomez, put it to me as to why the performance of DNA testing would make it reasonably probable that relief would be appropriate in this case.
Well, Ms. Lashley said that there were two people who came out of the Amoco. One was Mr. Alexander. The person who was Mr. Alexander was holding something in his hand and that he threatened to shoot her. The threat that Ms. Lashley said Mr. Alexander made suggested that he had the means to carry it out, as does Ms. Lashley's statement that he appeared to be holding something. And it's reasonable to believe that a person who's holding a gun that was just used in an armed robbery and shooting is the person who loaded the gun. The crime scene suggests a single shooter, and therefore if someone else's DNA were on the shell casings and projectile, this would forensically link the gun to someone else and call into question Ms. Lashley's identification of Mr. Alexander as the person, as one of the people who came out of the Amoco. And does that answer your question, Your Honor?
Yes.
Thank you. And as I said, we're not asking for drastic relief here. It's just a DNA test. Or even alternately, an evidentiary hearing on the motion. And it's only after the DNA testing is performed that there will be a hearing to determine if the results are favorable or unfavorable, and the judge will decide on a proper remedy if they're favorable. Therefore, Mr. Alexander should not have to show that the DNA testing would necessarily exclude his involvement in the crime as the Court of Appeals required. Brady materiality is a relatively low standard under Bagley, and as this court adopted in Byers, the Bagley standard of reasonable probability is a probability sufficient to undermine confidence in the outcome. Therefore, we would contend Mr. Alexander should only need to show enough to get his foot in the door. And in Byers, this court noted with favor the Court of Appeals majority's observation that in enacting 15A 269, our General Assembly created a potential method of relief for wrongly incarcerated individuals to interpret the materiality standard in such a way as to make relief unattainable would defeat the legislative purpose.
Can I just ask, in assessing whether or not this evidence would be sufficient to undermine the reliability of the outcome in this particular case, are we also supposed to consider the strength of the state's case here and the other evidence that the defendant had, that he wasn't there at all and that he had an alibi witness who included a police officer and all of the evidence surrounding his defense? Is that part of the materiality analysis?
Yes, because I would say so, because if he went to trial, he would have received all of this in discovery. So this is the universe of information that we have that we know is pretty much complete had the defendant gone to trial. He had started his trial, and the district attorney testified at the MAR hearing that the whole case depended on Ms. Lashley's credibility. So this isn't a situation where 2 days after a crime was committed, the defendant pleaded guilty and we don't know what other evidence the state would have had. So we would contend because, and that first of all, the attachments should be considered in favor of the defendant, just as the attachments to an MAR are construed in favor of the defendant. And if there's any doubt as to their authenticity, then there can be a hearing. Some of these witnesses may be available and they may be able to testify from memory, authenticate the documents, maybe have their recollections refreshed by the documents, or there could be past recollection recorded and so on. So I think at this point, to take all of those attachments at face value. And as well, we should consider that in 2004, Dominic White told federal authorities that another person confessed to him that he was the murderer of Carl Boyd, and that they went to the woods to get a .22 rifle, and that there was, we know that there was a .22 that was used in the killing of Mr. Boyd. And we believe, and the state v. Best, this court's opinion in Best, for the proposition that you can't look at anything that happened after, the sentencing hearing. So Best is a Brady case, and purpose of Brady is to guarantee the defendant a fair trial and also to deter prosecutors from withholding exculpatory evidence. And that is not the situation that we have here. This is a totally different context. And we would contend, well, in Best, to allow the prosecution to introduce post-trial evidence to show a lack of prejudice would undermine the deterrence function of Brady. But as I said, that is not the situation we have here, and Brady should not be used as a weapon by the state to deny a defendant the ability to show materiality in this context.
In assessing materiality in this case, how would we juxtapose that evidence that is favorable to the defendant and a showing of materiality against the evidence, which in this case would include that of this individual, Terry, who disassociated himself from everything that the defendant was claiming would enhance his ability to show materiality?
In terms of how we construe his testimony, Mr. Terry's testimony.
Materiality, and certainly looking, as you were responding to Justice Earle's question, that there would have been, but for the guilty plea, some evidence which would have inured to the benefit of the defendant, which would have helped him. But in terms of looking at that in a materiality context, how would we as an appellate court look at that kind of evidence vis-a-vis the evidence which would detract from that, such as the individual Terry, upon whose representations the defendant is relying when Terry testifies, says, I don't know anything about this, I wasn't at the gas station, and I don't even know the defendant.
Right. Well, the fact that he didn't know the defendant certainly helps Mr. Alexander. I also note that Terry also testified that if he had killed and robbed someone, he would not admit it. And I think, you know, we may have, I guess, just a conflict in material fact, is that John Terry says one thing and Dominic White says another thing. And that could either be a remand, or this court could decide, well, we're going to construe things in the light most favorable to Mr. Alexander. We've never really reached this point in one of these DNA testing cases.
How would we look at that in terms of assessing reasonable probability based upon what you just said about looking at this through the beneficial eyes for the defendant?
Well, I suppose that a reasonable probability, as I said, should be a fairly low bar. And I think if you look at the other facts that have to do with, you know, what, Dominic White said happened with John Terry, that those facts line up so well with what happened to Mr. Boyd, that there should be some, you know, weight given to Dominic White over John Terry, especially because he said, I wouldn't admit it if I killed somebody. I hope I'm answering your question, Justice Morgan.
You are. Thank you.
Thank you. And here we would say that all the documentation should be considered, including the John Terry and the Dominic White. If the court's not inclined to consider that information, well, in State v. Best, there was an IAC claim besides the Brady claim, and although this court did not, the IAC claim had to do with a timeline and not bring out some problems in the timeline at the trial, and this court said, well, we're not, you know, wrapping that IAC claim up into our Brady analysis, but it shows that we're making the right call in the Brady analysis. So we would ask, even if it's not wrapped up into the analysis, it really serves to emphasize materiality in this case. And the documentation shows, first, there was a robbery at 7 a.m. at a welcome center located located 2-3 minutes drive from the Amoco on the same day as Carl Boyd's killing. And the robber used a sawed-off shotgun or sawed-off .22 rifle. The robber only got $78. The wife of the man who was robbed got a better look at the robber than did her husband. And when shown pictures of Mr. Alexander, she did not identify him as the robber. Then Carl Boyd was killed and robbed at the Amoco sometime between 7:10 and 7:19, according to the accounts of Mr. Bolton and Mr. Henderson. He was killed with a .22 caliber weapon. Then, as we've talked about, in 2004, Dominic White told federal authorities that around 1992, his friend John Terry told him he stole a white car and robbed and killed Boyd. And the Welcome Center robbery was also committed with a white car, and that car left at 7:10. Then Mr. Boyd is killed between 7:10 and 7:19. And then Dominic White says his friend John Terry stole a white car, robbed and killed Boyd. And White testified at the MAR hearing that it was his understanding that there was only one person involved in the crime. And as we also said, the gun that they retrieved from the woods was a .22 assault rifle short barrel. Terry testified at the MAR hearing that he did not know Mr. Alexander. In addition, based on Willie Alexander's and Tanika Brown's statements, Mr. Alexander would have a strong alibi. Finally, according to the documentation attached to the DNA motion, Ms. Lashley gave conflicting accounts of what occurred, most notably telling Detective Aiken that Mr. Boyd died clutching her hands and telling Agent Sims that she only briefly entered the Amoco behind the paramedics. Based on this documentation showing how things would have played out at a trial, if the murder weapon had been linked to a person not connected to Mr. Alexander, there's a reasonable probability Mr. Alexander would not have been convicted. And we would ask this court to affirm the portion of the Court of Appeals opinion allowing guilty plea defendants to make DNA testing motions and to reverse the portion finding a lack of materiality. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. May it please the court, my name is Kristen Euchre. I'm an Assistant Attorney General with the Department of Justice, and I represent the state in this matter. A defendant who pleads guilty has not required the state to put on any evidence. Accordingly, he's not entitled to post-conviction DNA testing, which allows defendants who went to trial the opportunity to subject the evidence used to convict them to newer DNA testing technologies. Our post-conviction DNA testing statute presupposes a defendant who pled not guilty and required the state to present its evidence at trial. This conclusion is supported by the plain language of the statute as well as the underlying legislative purpose for which it was enacted. Starting with the use of the word verdict, the materiality standard is that a reasonable probability that the verdict would have been different. Verdict means the decision of a jury. That's what it meant in 2001 when the legislature enacted Section 15A 261 or 269 rather, sorry. And that is even further bolstered by Section 15A 1237, where the legislature specified everything that had to be in a verdict, which obviously that section does not define a verdict, but it says a verdict must contain these features, which are all things that presuppose a jury. There's no need to guess at what the legislature meant when it said verdict, because it has told us there in 15A 1237 that it means the decision of a jury as evidenced on the verdict piece of paper.
How does that depiction of what verdict means relate, in your view, then to the allowance of a bench trial
Yes, Your Honor. First, I don't know that that matters for the legislative intent because the statute has not been amended at all since that change in law occurred, which that was in, I believe, 2013. But even if it does need to be harmonized, I guess, with the statute, this court and the Court of Appeals have repeatedly recognized that a bench trial in a criminal case still results in a verdict. The relevant question is, was it a contest of, or where the state was put to putting its evidence on to convict the defendant? So even a bench trial is still results in a verdict. The citation from the Court of Appeals majority opinion to the rules of civil procedure, which I believe define the decision of a bench trial in a civil case to be a finding rather than a verdict, that simply doesn't apply in criminal cases. This court had long held that bench trials in criminal cases still resulted in verdicts, and the legislature is presumed to know that that was the terminology used even in a bench trial in a criminal case. Moving on to the provision that the testing must be material to the defendant's defense. A defense is a trial strategy that is aimed at procuring acquittal. All defenses are waived by a guilty plea. This court has said that time and time again, including in State v. Caldwell. All defenses are waived by the guilty plea. So the defendant, by definition, had no defense when he's pled guilty. So there is no way in which to analyze the effect of any DNA testing on something that does not exist. Even a defendant who goes to trial and remains completely silent has the defense of putting the state to its burden to prove him guilty. Moreover, this court's decision in Lane that held that the materiality standard in 15A 269 is the Brady standard, and also bringing in all the other parts of the Brady test into the materiality standard from 15A 269 is relevant in that if the legislature selected the Brady standard, and the Brady standard has only ever been applied in trial context in any sort of controlling precedent, then they necessarily intended it to only be a right available to defendants who went to trial, the post-conviction DNA testing. There's even controlling precedent that holds that at least one aspect of the Brady right is waived by a guilty plea. That's United States v. Ruiz, which holds that there is the guilty plea waives the defendant's right to receive any impeachment evidence, any material impeachment evidence. So if the legislature has adopted this standard that is only ever applied to trials, there is absolutely no reason to believe that they intended the standard to also somehow transform into one that could be applied to a guilty plea context. Guilty pleas waive a variety of different rights, including trial rights like the right to confrontation, trial by jury, the privilege against self-incrimination, and the right to impeachment evidence, as I just said, from Ruiz. And it also waives many appellate rights, which the legislature specifically did in Section 15A 1444E. So the idea that the legislature has created distinctions between individuals who've pled guilty and individuals who have opted to exercise their right to trial is not a new one, and is not some sort of a crazy supposition on the state's part.
Ms. Schicker, it does, I mean, there's no argument that I've heard so far in this case that a guilty plea waives the right to file a motion for appropriate relief. Is that right?
Your Honor, that has not, motions for appropriate relief have not been discussed in this case, no, Your Honor.
And do you know of any limitation upon the ability of a person to file a motion for appropriate relief based upon the fact that the defendant pled guilty?
Well, Your Honor, I do not believe that the MAR statutes mention verdict or defense in the same way that 15A269 does, which
Of course,
those
I don't know that the appeal statute does either, does it?
no, but it does specifically say except for defendants who pled guilty, or I'm forgetting the exact.
It limits what's, what rights might be available. It doesn't totally foreclose appeals based on the guilty plea. I mean, don't you just have to look at every statute individually rather than try to rely on one or the other as an analogy?
Yes, Your Honor, you obviously, yes, you do have to look at each statute individually, and this statute says that it must have been material to his defense and a reasonable probability of a different verdict. That the verdict would have been more favorable, sorry. So the word verdict simply, it requires adding words or taking away words, just as Randall did, the Court of Appeals opinion in Randall. They had to fashion an entirely new test because Section 15A269 simply doesn't cover the guilty plea context and is not meaningfully applicable to a guilty plea. And that is not something that a court is supposed to do when it interprets statutes.
So I want to ask if it's your position that the entire statute is inapplicable to anyone who pleads guilty. And in particular, I'm wondering about subsection H, which says nothing in this article shall prohibit a convicted person and the state from consenting to and conducting post-conviction DNA testing by agreement of the parties without filing motion for post-conviction testing under this article. So do you contend that that section would not allow the state and a defendant who pled guilty to, by agreement, by consent, have post-conviction DNA testing?
Your Honor, I'm not sure that section H, actually truly does anything. I don't know that a statute is required in order for the state to enter into an agreement with any defendant. As far as whether you can essentially sever different parts of the statute and say these apply to people who pled guilty and these apply to people who didn't. I think that even reading subsection H, it says nothing in this article, which would include this section itself. So even if the rest of the section is completely off limits to a guilty pleading defendant, subsection H says notwithstanding that limitation, the state can still agree.
So then you're saying this section does apply to people who, where a conviction was obtained via a guilty plea?
That the state may enter into an agreement to do post-conviction DNA testing. Yes, Your Honor, because on the terms of that subsection, it says nothing in this article prohibits that, which would include any other part of section 15A269.
A second question I have is whether in understanding the purposes of allowing post-conviction DNA testing, does it matter that a guilty plea is obtained in the context of a defendant who's facing capital murder charges and the death penalty, where there would be reasons independent of what the defendant actually did that would encourage them or be a motivation for pleading guilty?
Your Honor, I don't think so. The United States Supreme Court has held that pleading guilty to avoid the death penalty is not inherently coercive, such that it violates his Fifth Amendment right against incrimination, self-incrimination.
I guess my question is getting at, if the legislature wants to make sure that people who are actually innocent have an avenue to obtain evidence that might establish that they are actually innocent, because of the interest that the actual guilty party for this particular crime should be punished under the criminal justice system, if the state has an interest in making sure the right person is ultimately convicted, and we have a situation where there's at least an understandable reason why a defendant might plead guilty when in fact he was not there and not guilty, how would it not be in keeping with the purpose of the statute to deny at least the opportunity to have the testing?
Because that's not the way that the criminal justice system works. The defendant's opportunity to vindicate his innocence is at trial, and he has purposefully foregone that opportunity. I completely understand what Your Honor is saying about there being other considerations about why a person might choose to plead guilty rather than going to trial. But the criminal justice system as a whole it's founded on the right to trial, right? I shouldn't say founded, but that's the heart of it. Is that all of the rights that a defendant has go toward the fairness of the proceeding that determines whether he's guilty or not. And the defendant has foregone that in a case where he's pled guilty. And so it's simply, it's not, it appears the legislature has decided that it's not a good use of resources to allow the defendant to forego that opportunity and then to years later require the state to expend more resources in order to continue investigating the crime he's already pled guilty to, including in this case where he said he was in fact guilty of the crime. And to continue to question and disturb the finality of the guilty plea. And
well, but issues about finality and whether or not, I mean, those are present in any conviction, and what the general, so our purpose or our mission is to interpret the intent and give effect to the intent of the General Assembly. And I guess what I'm asking is, how is it consistent with the intent of the General Assembly to allow post-conviction DNA testing to draw this distinction between convictions obtained through a jury verdict and convictions obtained through a guilty plea?
because the General Assembly has merely on the face of the statute necessarily circumscribed the class of defendants who are able to take advantage or who are able to require the state to perform further testing of the DNA evidence or of evidence that might contain DNA. So, for example, if they had truly wanted everyone to be able to access this at all times without any other caveats, there would be no need for the materiality standard at all. There would be no need for an affidavit of innocence. There would be no need for any of those showings if it was simply to open this avenue to every single person. The statute is designed to narrow the class of people who can require the state to expend further resources in defending the conviction.
Well, it just seems, and I'm not suggesting that the statute permits any and every defendant. As you point out, there are all these other requirements that have to be met. But if I'm understanding your argument correctly, what should lead us to the conclusion that the General Assembly intended to exclude from the coverage of this statute anyone who pleads guilty is the use of the word verdict?
Verdict and defense, Your Honor, as well as reasonable probability that the verdict would have been different, which is the Brady standard, which is a trial right.
Thank you.
This court has already considered this question in State v. Sayer, where this court per curiam affirmed the Court of Appeals. The Court of Appeals opinion said, moreover, by entering into a plea agreement with the state and pleading guilty, defendant presented no, quote, defense pursuant to section 15A to 69A1.
Was the guilty plea issue directly presented for our consideration in Sayer?
Your Honor, in Sayer, the question that made it to this court was whether the defendant had met the materiality standard for appointment of counsel. However, in Byers,
In the question of whether a guilty plea precluded assertion of a claim under the statute did not make it to this court, did it?
no, Your Honor, it did. It's part of the same consideration. It's the same standard, materiality for appointment of counsel.
Was that issue briefed before us?
I'm not aware if it was briefed, Your Honor. Off the top of my head, I don't recall. I don't believe that it was. But the materiality standard is the materiality standard. That's what this court said in Byers. In Byers, this court did recognize maybe a difference in the level of proof required to show materiality, but the content of the materiality standard is equivalent, whether you're talking about for appointment of counsel or for the ultimate showing of entitlement to post-conviction DNA testing. So the issue was, it was subsumed in that the question of materiality for appointment of counsel.
Are you relying upon Sayer as controlling here?
Yes, Your Honor. Yes, I believe that when this court affirmed it, it became controlling precedent of this court, which necessarily overruled the Court of Appeals' slightly earlier decision in Randall. Randall came out, I believe, 3 months before this court affirmed Sayer. But even if this court doesn't decide that Sayer is controlling, for all the same reasons that I've already discussed, this court should still hold that the statute requires a person who has pled not guilty rather than a person who pled guilty.
Ms. Euchre, do you by chance have any of the Sayer brief from that was to this court that's been asked about? Because I'm looking at page 10 of the defendant appellate's new brief, and section A, the first issue says, based on the plain language of the statute, a defendant who pled guilty to the charged offenses is precluded from requesting relief through post-conviction DNA testing because review for materiality is simply not possible. And then there is a discussion about what the Court of Appeals did on page 11. Can you comment on that at all? Do you have that in front of you, or was that something you studied?
I do not have it in front of me right now. I believe I do have it on my computer in my many materials. I simply didn't want to misrepresent to the court, because I do know that this court didn't issue an opinion or did not write an opinion. So I didn't want to overstate to the court. I believe one of my colleagues did argue Sayer, and I have some vague memory of it.
Well, and I certainly don't want to make that the actual issue, but I had read that, and if you were familiar with it, you could comment on it. But in any event, just please continue.
Thank you, Your Honor. I'm sorry that I don't have that material in front of me. Yes, if there are no further questions about the guilty plea aspect, I guess I'll move on to materiality in this case, whether the defendant has shown materiality in this case. So I think that the first important question here is what information is appropriate for this court to consider in the materiality analysis. So if this court has determined that the defendant can still show materiality despite having pled guilty and said he was in fact guilty of this crime, and necessarily then committed perjury at his plea hearing, the only information to be considered here is the trial record from 1993. As this court said in Best, the question is not whether the defendant is guilty or innocent, but whether there's a reasonable probability of a more favorable verdict here with the requested DNA testing. As a result, evidence that was produced after the conviction, which may tend to support or negate guilt or innocence, is not properly considered in this analysis. My colleague suggested that the state is using Best as a weapon. The state is not using Best as a weapon. Best is simply the rule stating what is the proper material as best evidence is. Sometimes that rule is to the state's detriment, as this court held in Best, and sometimes it operates to the state's benefit. It is not a weapon, it's merely the rule, and this court has said that it is the rule in Brady cases. And that is merely a clarification or distillation, if you will, of even older case law, going back to, I think, the 80s, that that is the proper question, that the court should not engage in speculation about what evidence might have been presented but was not. That's reflected in footnote number 5 in Best, which the defendant is saying that the court here should do, that the court should speculate what the evidence at a trial might have been based on the reports that were compiled by law enforcement officers back in 1992 during the investigation, which is simply, the reports were written by the law enforcement officers, not by the witnesses, which is entirely possible that there was any sort of misunderstanding, miscommunication, or something was left out. And even more importantly, don't always testify in accordance with the statements that they have made before. Sometimes they make corrections while they're on the stand, or they say new things that they didn't say in their report, or in the out-of-court statement. So that is just one of the assumptions that the defendant is trying to stack here. He's trying to stack 4, 5, 6 something assumptions together to arrive at this conclusion that the post-conviction DNA testing would be material. One of the other assumptions is that somehow undermining the idea that the defendant was the shooter would make Miss Lashley's identification unbelievable. That's simply not the case. Miss Lashley was absolutely clear that she never saw either of these men with a gun. She said that she did not see the defendant holding a gun, and she did not see the other man holding a gun. So defendant wants to essentially assume that that Ms. Lashley's testimony can only be interpreted in that way, which then, I don't even want to say undermine, because showing that somebody else might have touched the ammunition at some point has absolutely no bearing on who shot Mr. Boyd or on whether someone else was present when Mr. Boyd was shot. Similarly, the fact that defendant threatened Miss Lashley, threatened to shoot her, does not mean in any way that he in fact had a gun. Obviously, a person can threaten to shoot someone without having the ability to carry out the threat. And it's also eminently possible that he said, "I'll shoot you," meaning someone, the accomplice would shoot. The point is, Ms. Lashley's testimony does not put a gun in the hands of Mr. Alexander. And so anything that tends to show the gun was in anyone else's hand has no bearing on her credibility. Defendant faults the Court of Appeals for explaining its holding on materiality by saying that the test results would not exclude defendant. That statement is not at all the Court of Appeals creating a new standard. In the majority opinion in this case, the Court of Appeals recited the proper standard from 15A269, as well as this court's holdings in Lane. The language that he's complaining about is simply the way that the Court of Appeals explained its reasoning. It wasn't increasing or creating a different standard. And this court even used the word exculpate to describe this, the materiality standard in 15A269. That was in Byers. And that's a direct quotation from Brady v. Maryland. Brady v. Maryland talks about exculpating and exculpatory. And furthermore, defendant's own DNA testing motion uses the same language twice to explain how the testing was material. He says that the testing is material because the presence, quote, the presence of John Terry's DNA would exculpate defendant. That's on record page 27. And then also that John Terry's DNA on the casings, quote, would have exculpated defendant. That's on record page 33. The Court of Appeals was simply explaining its reasoning. It was using words that have been used in expounding upon the materiality standard and the words that defendant himself used in his motion to the trial court. Defendant fails to show error in the Court of Appeals majority opinion. This court should modify the opinion to clarify that guilty pleading defendants cannot meet Section 15A269's materiality standard, and then otherwise affirm the majority opinion. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
Can you hear me, Your Honors? Thank you. Yes, just very, very briefly. This court has, and our Court of Appeals have never found that a defendant has demonstrated materiality, except in the Court of Appeals in Byers, which this court overturned. And besides giving Mr. Alexander relief, we would ask in general for some guidance for the criminal defense bar, as well as all of the pro se defendants who are unable to show materiality. What exactly is required? And because of the small modicum of relief that one gets from having one's motion granted, we would ask that this court find that materiality is a low bar, just to get your foot in the door. If there are no other questions, that will conclude my argument.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.